the Northeastern University School of Law 5th Annual Lecture in Health Policy and Law, hosted by the Center for Health Policy and Law. My name is James Hackney, and I'm the Dean of the Law School. The Center for Health Policy and Law is one of our 3 centers of excellence situated within the law school. Consistent with the university's Northeastern 2025 goals, the center strives to create and strengthen interdisciplinary collaborations across the entire university. Faculty associated with the center represent numerous fields of study, including law, health sciences, business, political science, and chemistry. In addition to the fall lecture, the center hosts a robust portfolio of events, including an annual health law conference in the spring, monthly roundtables, and a diverse array of health-related topics, and community forums designed to address and discuss timely state and national policy and law issues. The center also actively engages with students by supporting our Health Law Scholars Program, as well as our Health Law Society, mentoring law and health sciences students, and organizing student-focused events and initiatives, such as a yearly health law networking reception, film screenings, and discussion and advising groups. The center also supports and disseminates to scholars, policymakers, practitioners, and health policy and law research of our faculty, both here at the law school and across the university. The Center for Health Policy and Law has experienced tremendous growth over the past couple of years, and we are all excited to see Northeastern's reputation for excellence in health law continue to flourish. Now, without further ado, I would like to introduce the Center for Health Policy and Law's Faculty Director, Professor of Law, Wendy E. Permet, who will introduce today's speaker.
Thank you, Dean Hackney, and thank you not only for those great introductory remarks, but for your support for the center and for health policy here at the Law School and the university. And thank you so much to Jennifer. You are our executive director, who, as always, does an amazing job in putting events together. We could not do half of what we do without Jennifer. Before I introduce our speaker, I just want to mention a couple of additional upcoming events. On December 14, co-sponsored with the Law School's Domestic Violence Institute, we're putting on a one-day conference called Finding the Nexus, Linking Systems for Domestic Violence Survivors. And you can find more information about that on our website. And then on April 11th and 12th, our annual spring conference. This year, it's on Promises and Perils of Emerging Health Innovation. It'll be a 2-day gathering of interdisciplinary experts, scholars, and practitioners and students who will discuss and search for answers and brainstorm solutions to potential interventions that arise around emerging health innovations. We are super excited about that. So I want to introduce our speaker today. I can't even begin to tell you how excited and thrilled I am to have her. There are years in which it doesn't immediately come to me. You know, it takes a while for Jennifer and me to sort of brainstorm and think, who do we want to invite? Okay, and everybody we've invited is great. Sometimes it takes a few minutes or a few days or even a few weeks. This year, it was, you know, I'm working on something and I suddenly said, oh my God, right? We need to ask Brigitte. Oh my God, she said yes. And so I'm so thrilled. Brigitte Amiri is the Deputy Director of the ACLU's Reproductive Freedom Project and a proud alum of this institution. Over the past year, and this is how I really have been at the center of a national high-profile lawsuit that challenged the Trump administration's policy of denying access to abortions for undocumented detained immigrant women. In 2017, she successfully argued on behalf of a 17-year-old woman known as Jane Doe, who was eventually able to get abortion care after an appeals court in Washington, D.C. issued a decision that cleared the way. You might have heard about this case too, because now Justice Brett Kavanaugh dissented from the en banc decision, and this case was discussed at length in the Kavanaugh hearings. The fight, though, although Jane Doe was able to have her fight, continues with a class action against the United States Department of Human Services. So maybe we'll be hearing more about that. In addition to this litigation, she has overseen litigation in Kentucky to keep the state's last abortion clinic open after the state government threatened to shut it down over deficiencies in a hospital transfer agreement. She's also litigating other cases around the country, including a challenge to South Dakota law that requires women seeking abortion to first visit a crisis pregnancy center, a restriction on Medicaid funding in Alaska, and a novel case against one of the largest Catholic hospital systems around the country over its ban on tubal sterilizations. She's also challenging the Trump administration's rollback of the contraceptive coverage under the Affordable Care Act. It's something that's actually gotten less attention than I would have thought might have, but then again, there's so much news these days. And she's heavily involved in helping to defend that benefit. She was heavily involved in helping to defend that benefit during the Obama administration, coordinating amicus briefs in response to the challenges brought on behalf of employers that were claiming exemptions. Before joining the ACLU, she worked as an attorney at South Brooklyn Legal Services in the Foreclosure Prevention Project and at the Center for Reproductive Rights. And as the bio should make clear, she really is at the center of so many storms that are happening these days. So I'm sure she has a lot to tell us, and I am really looking forward to hearing what she has to say. And please welcome me in joining Brigitte Amiri.
Mostly talk about what happened, cases are, and what it might mean for the right to abortion. And I like to think of, unfortunately, Jane Doe as a canary in the coal mine. That if the Trump administration could do to all people who seek abortion what they did to Jane Doe, the Trump administration would. So I have a bit of a hodgepodge of slides here. The nice ones were done by my colleagues, and the really bare bones were done by me. I'm not so good at PowerPoint. I'm a better litigator than I am a PowerPoint maker. So let's start with some of the basics. So unaccompanied immigrant minors are minors that come to the United States on their own. This is very different than families that come together and that are separated at the border. That's another ACLU case challenging the family separation policy. But these are minors who come by themselves, often fleeing abuse, torture, sometimes abuse at the hands of their parents, and they come to the United States on their own, seeking a better life. And usually they know that there is a family member in the United States who they want to be with. And that's what happens to most of these minors. They are reunified with what's called a sponsor in the United States. After they cross the border, they're detained by our government. They're placed in Health and Human Services custody, and their day-to-day needs are cared for by Health and Human Services initially until they can be placed with a sponsor, or they can seek asylum, or they're deported to their home country. So the Health and Human Services sub-agency that oversees these minors is the Office of Refugee Resettlement. Years ago, there was a lawsuit brought as a class on behalf of all of the unaccompanied government custody And there was a consent decree issued in this Flores litigation that says that all unaccompanied immigrant minors who are in government custody must have access to routine medical care, family planning services, and emergency health care services. No abortion exclusion, right? So by law, by this consent decree, minors seeking access to abortion must have access to it when in government custody. The Jane Doe case actually begins in some ways in 2008, when 4 social workers were fired from a Catholic Charities in Virginia for first helping a minor access contraception and then access to abortion. They were fired for failing to follow Catholic teaching, and there were shockwaves against the Bush administration at the time and Catholic services. Let me take a step back and say that the federal government does not provide direct care to unaccompanied immigrant minors. They have contracts, multi-million-dollar contracts with shelters, both secular and sectarian across the country to provide this day-to-day care. A lot of those, the U.S. Conference of Catholic Bishops runs a lot of those shelters, and they have a religious objection to providing access to abortion and contraception. And that really manifested in 2008 when these 4 social workers were fired for helping an unaccompanied immigrant minor in their physical care access abortion and contraception, even though, as the Flores Settlement Agreement says, they are legally entitled to access those services. So I started doing a FOIA first to find out what was going on. What is the government's policy with respect to access to abortion and contraception for this marginalized population that people didn't know very much about? I started getting some documents, and then there was an election. Obama won, and we started meeting with Office of Refugee Resettlement at the time and saying, what are you going to do about this prohibition on access to abortion and contraception for unaccompanied immigrant minors who are in religiously affiliated shelters? And the Obama administration basically said nothing. So we said, we can sue you, and we did. So we brought an Establishment Clause challenge against the Obama administration in June of 2016, saying that it was unconstitutional for the government to give millions of taxpayer dollars to religiously affiliated entities and allow those entities to impose their religious beliefs on the marginalized population that they were to serve, contrary to what was guaranteed by law in terms of access to abortion and contraception. We filed that lawsuit in the Northern District of California, and we started getting discovery documents, and then another election happened. And in 2017, we started getting documents in discovery that were really disturbing. We started getting documents after, this is Scott Lloyd, who took the head of the Office of Refugee Resettlement. Scott Lloyd has virtually no experience providing any sort of services to refugees or doing immigration policy. Instead, his entire career has been based on largely anti-abortion work. And I think he was selected for this job in part because of that. So Scott Lloyd starts imposing his religious beliefs on the minors in ORR care. So we've started getting documents after he takes office in discovery about how grantees, and those are the shelters, should not be supporting abortion services pre or post-release, only pregnancy services and life-affirming options counseling. So we started thinking about how are we going to challenge this? Like, this is clearly wrong. We don't know precisely what's happening, but now it seems like the federal government isn't just authorizing religiously affiliated shelters to block access to abortion, but that the government is doing it itself. And we were trying to figure out how we were going to incorporate this new constitutional violation into our existing case. And we're getting more documents and trying to figure that all out. And then I got a call from an amazing organization in Texas called Jane's Due Process. And Jane's Due Process helps minors in Texas who are seeking access to abortion go to court to get a court order instead of telling their parents that they want an abortion. So Texas, like many states, including Massachusetts, has a law that says that if you're a minor, you have to get your parents' consent before having an abortion. And if you can't tell your parents or don't want to, you have the option of going to court and seeking a judicial bypass of that requirement. You have to show that you're mature enough to make the decision or that the abortion is in your best interest. So Jane's Due Process has a network of attorneys across Texas that they match with minors seeking access to abortion to help them go to court and get these judicial bypass orders so that they can confidentially access abortion without involving their parents. And it was the legal director at the time, Susan Hayes, who contacted me knowing that I had been researching this issue and knowing that I had this case ongoing, and said, we have an attorney in our network in the Rio Grande Valley. Her name's Rochelle Garza. She's been helping this minor, who will eventually become known as Jane Doe, access abortion. And the government is saying that in order for Jane Doe to access abortion, she must first visit an anti-abortion crisis pregnancy center and get counseled, and to have an medically unnecessary ultrasound and view the image, and that she must tell her parents in her home country that she is seeking an abortion. Well, Jane Doe was abused at the hands of her parents, and she even saw her parents beat her sister after her sister revealed that she was pregnant. And nevertheless, the government was insisting that she tell her parents that she was pregnant. And I said, well, that's not constitutional. They can't force someone to go to a crisis pregnancy against their will, and they can't tell the parents in the home country. And so I called the Department of Justice, my opposing counsel in the Establishment Clause case, and I said, you can't do this. And I sent a furious email with a bunch of cases, and before I could even get a response, Susan Hayes calls me back and says, now the government is just saying that Jane Doe is prohibited from leaving the shelter for any abortion-related appointment. That includes the pre-abortion counseling that is required by the state of Texas and the abortion itself. I was like, well, that's definitely not constitutional. And I called the Department of Justice again, and I said, you can't do this. And the Department of Justice said, this is what our client wants. And I said, well, then you won't be surprised when we see you in court. And that's exactly what we did. We first tried to amend our existing case, the Establishment Clause case in the Northern District of California. This case is, has some thorny procedural issues, and the legal issues are really clear cut. But stick with me in terms of all the procedure, and feel free to raise your hand if you get lost with all the twists and turns. So we tried to amend in California, and we filed a temporary restraining order, also a complaint. We amended our complaint. We sought a preliminary injunction on the class. We hadn't filed a class action yet, but we were immediately trying to get Jane access to an abortion. She was 9 weeks pregnant when she first asked for an abortion, and Texas bans abortion at 20 weeks. So the clock is ticking, and although abortion is very safe and safer than childbirth, every week that goes by increases the risks associated with the procedure. Not to mention, once you've decided to have an abortion, to be held hostage by the federal government and to remain pregnant against your will is just cruel. So we're moving as fast as we possibly can. Unfortunately, the district court judge in the Northern District of California said venue's not appropriate here. We're not going to let you amend the case in California. And so that left 2 options. We could file in the district court in DC or in Texas. So we went to DC. And we drew Judge Tucktan in the DC District Court, and Rochelle Garza was the plaintiff on behalf of, as guardian ad litem for Jane Doe, because in the context of the judicial bypass, the Texas courts appoint a guardian ad litem and attorney ad litem, and Rochelle Garza was appointed as the guardian ad litem. So she sues on behalf of Jane Doe, and Harkin was at the time the HHS secretary, and now it's Alex. So we go into district court in DC, and we seek a temporary restraining order, and Judge Tucktan holds argument, and I race down to DC to argue it, and she's livid at the federal government for blatantly violating the Constitution. This is a clear legal issue. The government cannot, since Roe versus Wade was decided in 1973, ban abortion for anyone, and that's exactly what was happening here. She issues a temporary restraining order prohibiting the government from interfering or obstructing with access to abortion for Jane Doe, and the government takes an immediate appeal to the Court of Appeals. And that's the first time that I'm in front of the Court of Appeals on this issue, and Judge Kavanaugh was on the 3-judge panel. And this is all happening at lightning speed. All of us were up late at night writing briefs. I was getting 4 hours of sleep with the rest of my team. We had not even 24 hours notice that the Court of Appeals was going to hear argument. I literally took the suit off the back of my door in my office, didn't even go back to Brooklyn to pack, just got on the train and went to DC to argue in front of the Court of Appeals the next morning and Judge Kavanaugh. So there were also, protests at the time. I mean, I should say that it was an entire movement kind of surrounding Jane Doe, including protests and including our sister organizations calling for the removal of Stabloid. So Judge Kavanaugh issues a decision shortly after argument and says that the government should have more time to find Jane Doe a sponsor. So the government makes two arguments as to why this isn't unconstitutional, why it's not an undue burden on Jane Doe's access to abortion, which is the test after Planned Parenthood versus Casey. And they say that Jane Doe can just be released to a sponsor and she can have the abortion at that time, or she can voluntarily depart to her home country and have the abortion in her home country, although her home country banned abortion. And both of these processes take months. We had a declaration in the record from the former Office of Refugee Resettlement, Bob Kerry, who was the director under Obama, saying that the sponsorship process takes a long time. Sponsors have to be vetted, fingerprinted, background checks, sometimes home visits, and the government, that's all assuming that there is someone willing to take in the minor, and it takes time. But nevertheless, Judge Kavanaugh issues a decision saying that the government should be allowed 11 days to try to find a sponsor for Jane Doe. Judge Henderson joins him in that decision, and Judge Millett writes a powerful dissent. We knew that the government had already been looking for a sponsor for Jane Doe for 6 weeks. We knew it would take a long time. It was unacceptable to make Jane Doe wait 11 more days when we knew it was going to be an exercise in futility. Also, Judge Kavanaugh didn't say at the end of those 11 days, if there was no sponsor to be found, Jane Doe could just get an abortion. Instead, he said we had to go back and start our case all over again in the district court. He even vacated the district court's order. So we had no temporary restraining order even in place. And so then, and he said the government could appeal, and the government could make new arguments on appeal, not just to the Court of Appeals, but to the Supreme Court as well. That whole process could also take months. So we petitioned for rehearing on FONC, and our petition was granted. And a couple of days later, we got an amazing decision from the Court of Appeals that said that they were largely adopting Judge Millett's dissent in the panel, and Judge Kavanaugh also issued his own decision. So this is clearly my slide because it's so boring. So this is the only abortion case that Judge Kavanaugh now heard. So this is Judge Millett's really powerful dissent. I'll just give you a chance to read it. She said it better than any of us could in her decision, which then became the majority in the en banc decision. It's also just amazing when you think about what the government's arguments are with respect to the voluntary departure argument. That's just one of the things she's talking about here. That if you don't like the fact that we're violating your constitutional rights and this tremendous invasion of your bodily autonomy and integrity, you can go back to where you came from if you don't like it. So this case really sits at the intersection of the government's hostility to immigrants and to abortion. It was the epicenter of that hostility. So after we got the en banc decision, we had to go back to the district court to get a corrected temporary restraining order. This was a lesson learned, which I will pass on also. When we first got the temporary restraining order, we had specific dates in there that Jane could go to travel to the abortion clinic. Those dates clearly had passed by the time we got through the en banc decision, and we had to go back to the district court to get a new TRO to say she could go as soon as the doctor was available. So note to self, don't put dates in your TRO, just say that your plaintiff wins and she gets to go vindicate her rights. And so after Jane was able to access an abortion, she went to the clinic the next morning after we got the en banc decision and got a new temporary restraining order from the district court judge, and she issued this statement. So anytime I get tired, anytime I feel like I don't know that I can keep doing this because the fight feels like we're banging our head against the wall, I think about Jane. And I think, and this is also the part where I start to get a little emotional. Here is a 17-year-old girl who flees her home country. She was abused by her parents. She makes the perilous trek to the United States to seek a better life. She is detained by the federal government, and she is adamant, she is determined to exercise her constitutional right to abortion and to not become a parent. She knows that is her right. She decides to fight the Trump administration, even though they hold her immigration status in their hand, and they could retaliate against her for doing so. And nevertheless, she persists and she perseveres, and she continues the case as the class representative for an entire class of unaccompanied immigrant minors who are pregnant and seeking access to abortion. So Jane is able to get her abortion. 9 days after Jane gets her abortion, the government files a petition asking the Supreme Court to vacate the Court of Appeals victory and to sanction me and my colleagues. And the government claims that we acted unethically and misled them about the time of the abortion, and that the Supreme Court should investigate and take disciplinary action against us or refer the matter to our state bar. So this was kind of a gut punch. I'm a good Midwestern girl. I follow the rules. Never acted unethically in my whole life. But it's quintessential Trump administration, right? We won, and they were upset, and so they decided to come after us. And to vacate the Court of Appeals decision is also a little besides the point. The issue was about the temporary restraining order for Jane Doe. It had no precedential value. And nevertheless, the Solicitor General takes the time to try to vacate that decision and to punish us. The Supreme Court took many, many months to decide the issue. Ultimately, vacates the Court of Appeals decision as moot because Jane got the abortion, but doesn't change her ability to proceed as a class representative and does not take any disciplinary action against my colleagues. But going back to where we were after Jane got her abortion, we knew that there were other young women who were going to be facing this situation. And so we had our class action request pending and our request for a preliminary injunction pending, and we kept hoping the district court judge would rule, but this is something out of your hands. You can only, probe the court enough times to say, like, this is really urgent, we really need this protection. And unfortunately, she had not issued the class and preliminary injunction before we learned of other young women who needed access to abortion. And so we added them to the case. We amended our complaint and sought temporary restraining orders for 3 other Janes, Jane Roe, Jane Ho, and Jane Mo. And they all have their own stories that are compelling. And just to highlight one, Jane Ho was later in her pregnancy, she'd been raped in her home country. And Scott Lloyd issued a memo denying her access to abortion. And the memo is really chilling. The memo cites anti-abortion sources and comes to the conclusion that the abortion is not in Jane Ho's best interest because it would involve the destruction of human life, and the government should not be involved in the destruction of human life. And so it's completely backwards, right? There's not really consideration of what was in the best interest of Jane Ho, but really it's about Scott Lloyd's ideological opposition to abortion and his justification for why she can't access abortion while in government. We've got temporary restraining orders for Jane Roe and Jane Ho before we were able to secure a temporary restraining order for Jane Mo. She was released to a sponsor. So where we are now, again, this is clearly my slide. After we added 3 other Jane's case, finally on March 30th, the district court judge grants a preliminary injunction as to a class of all pregnant women for our custody and prohibits the government from obstructing or interfering with access to any class members' medical appointments related to pregnancy dating, non-directive options counseling, abortion, or other pregnancy-related care. She also prohibits the federal government from telling anyone about the minor's pregnancy or abortion decision against the minor's non-coerced consent. And the government then takes this up to appeal, and we just had oral argument on the appeal of the preliminary injunction and the class certification on September 26th, and we're waiting for a decision. In the meantime, we know the preliminary injunction is working. We've been monitoring what's been happening on the ground, and we know that we know of at least 6, maybe more minors that have access to abortion since the preliminary injunction was granted at the end of March. And we have no formal way of tracking it. It's just kind of word of mouth. We do have a class notice posted in the shelters with our phone number so that people know that they can contact us if there are any issues. And so far it's working, and we know we know that it's making a difference in people's lives. So I'm happy to stop there, take questions about Jane Doe. We can also talk about the future of the Supreme Court, because I feel like that is where this is all headed, right? I mean, we now know that Judge Kavanaugh, now Justice Kavanaugh, did not apply Roe versus Wade. This isn't the case, as Judge Millett says in her dissent. This isn't hard. The government can't ban abortion. And so for Judge Kavanaugh to write an opinion that would have forced Jane to delay even further. She was 15 weeks by the time that she got the abortion, and the government never did find a sponsor for her. She aged out of the program in January of this year. So, and luckily she's with a family member now. In case you're wondering where she is, she's with a family member who she wanted to be with, and she's seeking special immigration juvenile status by her parents in the home. But she would have had that baby by the time she was released from custody. So this idea that Judge Kavanaugh came up with, that the government should have 11 more days to try to find her sponsor, we knew at that point that it was happening, that it was a unicorn, and history proved that to be the case. So there is obviously deep concern that Judge Kavanaugh will provide the 5th vote to overturn Roe versus Wade, or at least gut Roe versus Wade. Perhaps it's an opinion that doesn't look like it's overturning Roe, but basically completely weakens the constitutional protection for abortion. And then if that happens, there will probably be about half of the states will ban abortion. And Massachusetts will not be one of them, and will be one of the beacons where women will need to come to get care. And the entire reproductive rights and justice movement is going to have to build an infrastructure to do the best that we can to shore up the beacons and fight like hell in the red states that are going to ban abortion, and also then try to figure out how we move people to where they need to go to get the care they need. But happy to take questions. There are lots of little nuances and lots of other tangents that we could go off on. I'm happy to answer questions or, yeah.
In the dissent for the appeals court decision, it mentions that the government failed a step. They didn't argue that the Constitution doesn't actually apply before getting to the undue burden standard, and that they should have. Why didn't they make that argument? And now with the change in the Supreme Court, do you think they will?
So it's an interesting question. So Judge Henderson joined Kavanaugh's initial opinion, but wrote her own concurrence in the panel, and then her dissent from en banc said that, and she was alone in saying this though, is that the government should have made the argument that the Constitution does not apply to Jane Doe in terms of access to abortion because she is here without documentation. But the government never made the argument. And during the appeals argument in front of the 3-judge panel with Judge Kavanaugh, Judge Millett pressed the Department of Justice attorney and said, are you making this argument? Are you going to make the argument that because of Jane Doe's immigration status, that her right to abortion is non-existent or diminished? And the Department of Justice said, no, we are not making that argument. And Judge Millett said, okay, that means you're waiving and forfeiting that argument for the entire case. And so they have not raised that argument. They have applied Roe and Casey. They've made their arguments within those boundaries. And why they made that strategic decision, I mean, frankly, I don't totally know, but there is no Supreme Court case, obviously, that says that the right to abortion is not diminished because of someone's immigration status, but there are lots of parallels about the substantive due process right. And if you look at the 14th Amendment, it doesn't talk about citizens, it talks about people here in the United States. And there are other cases, Supreme Court cases that we can draw on about the substantive due process right that we think are analogous, and perhaps the Department of Justice came to the same conclusion.
In regards to a lot of bills already in place for when Roe is overturned.
Yeah.
As soon as you start to say that Alabama is broad enough to allow prosecution and people who can plan leave or even had IUDs, is that possible?
Yes, I mean, I think it depends, how things are, how it's worded, and I know that that Alabama just passed an initiative, and I haven't had a chance to look at the language and figure out its effect. But the concern is that once there is a fertilized egg, that if a state protects life, so-called at the moment of conception, and if they're defining conception as the fertilization of an egg rather than the implantation of a fertilized egg on the uterine wall, which is the medical definition of pregnancy, then certain forms of contraception that may act to dispel a fertilized egg, like some forms of IUDs, that could run afoul of those laws. So that's what people are talking about, is about the mechanism of action of the particular contraception and this redefining of what pregnancy is and when it happens. But how you actually prosecute that, whether I think that's a harder thing to figure out. Yeah.
Could you, maybe you already talked about it, but could you discuss a little bit more under the Obama administration, how the government funded shelters were different?
Yeah, it's a great question. So Obama authorized the religiously affiliated shelters to kick minors out of their program for even requesting abortion. But then the Obama administration would then transfer that minor to a secular shelter, and the minor was able to get the abortion that she had requested after a delay, after being uprooted from her own network. And that was our concern, and that was part of our lawsuit, their Establishment Clause lawsuit, about the harm to minors who seek access to abortion in religiously affiliated shelters. But the Obama administration did ensure access to abortion, didn't limit access itself to abortion. And so Bob Kerrey, who was the former director of ORR, has talked about this in the press a little bit, that when he was the head of ORR, he didn't see his role as approving or denying the abortion itself, but it was just about payment. So federal funds can be used to pay for abortions in rape and incest and life endangerment. And so abortion requests would come across his desk, and he viewed them as, can we use federal funds to pay this, because is it consistent with what's called the Hyde Amendment, which is the amendment about restriction on federal funds for abortion. And so it was really a question of payment. And then Scott Lloyd decided to take on the whole issue of, I'm going to approve or deny the abortion. And he's never obviously approved an abortion, just denied all of them, or just done nothing and effectively denied them. So that's one of the fundamental differences between the Obama administration and the Trump administration in terms of access.
But the religious affiliations were always there.
Yes, exactly.
And the dollars have always been spent to keep them.
Yep, and unfortunately, we just got a decision at the end of September from the District Court in the Northern District of California ruling against us in the Establishment Clause case. So that was a disappointment.
Yeah. You talked about how you think that the Supreme Court may not necessarily completely overturn Roe, but just strip away rights. So what exactly would that look like? Would they overturn the new burden standard, liability?
Yeah, I mean, I think there are a number of ways that they can do it. So right now, under Planned Parenthood Casey, the test to evaluate abortion restrictions is whether the law places a substantial obstacle path of women seeking abortion, and it's been called the undue burden test for short. Whole Women's Health, which was decided in 2016, reaffirms that standard and clarifies the balancing test. So abortion restrictions need to be evaluated in terms of what how much the law benefits women's health and then how much it restricts access to the right, and then you do a balancing. And in Whole Women's Health, the restrictions that Texas had passed requiring admitting privileges for abortion providers that to a local hospital and ambulatory surgical requirements for clinics, the Supreme Court found no real medical benefit to women. These were bogus laws, essentially, and the burden on women in terms of access would be great given all the clinic closures in the state. So what could happen? It's kind of this intermediate scrutiny right now that we have, and so the Supreme Court could just say your rational basis review, and so any abortion restriction will just be evaluated under a rational basis standard. They could, I think that's one of the ways that they could do it, and then they could just then uphold the laws that they had previously struck down. At least in theory, and we would say that they don't even pass rational basis review, given that they don't really further women's health at all, and the government has to have a rational basis to act. But the concern is then, pick your state, Kentucky or whatever, could pass a law restricting access to abortion in the guise of protecting women's health, and that would be the Supreme Court might uphold that, and it would have the effect of closing the clinics. Or now only clinic in Kentucky.
So one, you talked about Whole Women's Health. I wonder, because that's so recent, do you see that as, is that on stronger footing, perhaps in Casey or Roe? So how strong is it, given, supposedly they're all in favor of stare decisis? So
right.
And then two, so what are the best kind of legal measures that the, call it the blue states could take now? And do you see that? That's kind of the roadmap for after, break the glass roadmap for after the Roe.
Yeah, great question. So yeah, stare decisis, 2016, the Supreme Court reaffirms Roe and Casey. And Casey itself talks a lot about the right to abortion and the reliance that people have had on the right to abortion, and we were at that moment in Casey. I mean, I was in high school, so I wasn't part of the case, but the collective movement was at this moment where people thought Roe v. Wade was going to be overturned, and it might have been. And if you read the 9 or other accounts of it, I mean, Roe was almost overturned. Was this plurality that was cobbled together to create that undue burden test. And so in Casey, the court talks about why they're going to uphold Roe, and it's about the reliance on abortion and what it has meant to people's lives and women's equality, and so all of those arguments should remain the same. So I think that's certainly a big part of what will be at issue. And then in terms of shoring up the states that are going to be the beacons for care, I think it's eliminating the restrictions that exist. I mean, Massachusetts has some work to do on that front. And the ACLU Massachusetts is involved in this. And if you go to their website, you can see what they're doing. But it's protecting legislatively the right to abortion. The Massachusetts Supreme Judicial Court has issued decisions about protecting the right to abortion in the Massachusetts Constitution, which is great. For example, in the Medicaid context, state dollars are used to pay for abortions in Massachusetts because of that state Supreme Court decision. But you have a parental involvement law on the books here, and you have the doctor-only law that says that only doctors can provide abortions. I think medication abortion, access to medication abortion, telehealth is going to be huge. There are pilot studies, for example, about mifepristone by mail, so medication abortion by mail. I think that's going to be really important. So I think it's getting rid of the barriers in the beacons that are going to be really important.
Thank you so much. This is great. Well, it's two very different questions. First is, you could talk about what Judge Kavanaugh's elevation to the court means in terms of the litigation strategy. So for many years now, certainly since Roe Women's Health, certainly during the Trump administration, when you, your colleagues, advocacy groups, ACLU have run to court to challenge the Trump administration. Is there now, are you sort of now going, to a different mode, which is trying to keep these out of the pipeline? As you think about, for example, the Alabama Personhood Amendment, is the decision now to challenge it or to, suck it up, so to speak, on the theory that, Alabama's putting it forward precisely to get an overruling from. So that's one set of questions. The other set of questions I'm interested in, not to scare people, is what do you think the chances are, and putting aside the House, this certainly lowers it, but do you see the administration, the anti-abortion movement, pushing eventually for a federalization, criminalization, using executive power, for example, to prohibit medication abortions, prohibit mail delivery of medication, to prohibit tele-abortions, right? I mean, you can imagine the Commerce Clause, not to mention additional spending, any healthcare center needs federal money, cannot do an abortion. So, attempting to limit what's happening in the blue states.
Yeah.
Do you see that as on their agenda?
I think yes. I'll take the last question first and say that yes, I think it's absolutely on the other side's agenda to ban abortion nationally. So this idea that when the other side talks about, oh, it's just a states' rights issue after Roe versus Wade is overturned, it's no problem, it'll go back to the states, I think is baloney. I think what they really want is a nationwide ban on abortion, and that once they achieve the reversal of Roe, if they are successful, and we will do everything to stop them, that will be the next thing. And where I started was, if the Trump administration could do to Jane, to the rest of the people in this country seeking access to abortion, it would. But the politicians have always started with the most marginalized. So when Henry Hyde passed the Hyde Amendment in the early 1970s, right after Roe was decided, he said, I wish I could ban abortion for every woman, but I can't. The only vehicle is the Medicaid law. And so it was a way of restricting access to abortion for low-income women. So I don't doubt that on their agenda would be a federal ban, and hopefully we don't ever get to that point. And I think that there are lots of constitutional problems with it. And the other insidious ways that this administration could use the FDA, for example, is also a concern as well. But I don't think we're holding back in court. The Alabama ballot doesn't have at this particular moment. So we have to go to court to vindicate our clients' rights on behalf of their patients. That's what we have to do. And so already I think that there are like 13 cases in the pipeline that could be the vehicle for overturning Roe versus Wade. And it's not as if we choose to not use the right that we have now to vindicate it in court, that somehow this issue is not going to come to the Supreme Court. So we will continue. I mean, obviously, there are state constitutions and state courts, and in those places we go there. Alaska Supreme Court, that's where we brought our Medicaid challenge for the use of dollars, state dollars, in their Medicaid program. So those are options, and when those are options, we can consider that. But I think we have to protect the right while we can. Yeah.
I'm wondering how your work within the reproductive rights movement has intersected with other work that's being done around immigration or racial justice, because like this individual experienced many different legal issues. It wasn't just access to abortion, but immigration.
Yeah.
I'm wondering how much these legal movements intersect and work together to address people's whole issues, not just pieces.
Yeah, I mean, it's a great question, and we're part of this larger community, not just with the ACLU, but also the states. So this case was really emblematic of that because of the issues that involve immigration. We were constantly talking to our Immigrant Rights Project, and the places where the Janes were located are state ACLUs. We're talking to their coalition partners, and making sure that those local groups were activated as well. And so, for example, Rochelle Garza, who's this attorney, wonderful attorney in the Rio Grande Valley, who was Jane Doe's guardian, was instrumental in all of this, and she also made sure that Jane had an immigration attorney for her special immigration status, and the attorney in Blightum, Christy has done some work on that. So it's really figuring out like who has the expertise and how can we connect people with the resources, even if it's not the work that we necessarily do. Jane Rowe is also very emblematic of that. She as soon as she was diagnosed with her pregnancy, she said she wanted access to abortion, and she was prohibited from accessing abortion. After we sued and tried to get a temporary restraining on her behalf, the government said, she's not 17, we have a birth certificate that she's 19, so ICE is showing up to take her away in shackles to a detention center. And we said, she has a birth certificate that says she's 17. And so our immigrant rights folks were brought in, the affiliate, ACLU affiliate, had their coalition partners, like with her making this decision, because the government said to us and said to her, ICE has a policy of allowing abortion access. I mean, this is also what makes all of this crazy, right? So if you go to ICE custody and admit you're 19, you can have the abortion in ICE custody. If you stay in or our custody and you can continue your lawsuit, but you might not be able to access abortion, and we're here to take you away in shackles, which, by the way, is impermissible. You cannot shackle pregnant people under ICE standards. So we had this whole group of people on the phone trying to figure out how to advise this 17-year-old about what she should do. And in the meanwhile, the government has appealed our temporary restraining order to the Court of Appeals. So some of us are getting ready to write those briefs. Other people are on the phone. I mean, it was insane. And then towards the end of the negotiations, they said, okay, fine, we'll transfer her to ICE custody, but then we're going to release her on her own recognizance, and she has to leave the ORR shelter immediately. So it just, bizarre. So that's, we were drawing on all kinds of resources in the national office, our state affiliates, their coalition, figure out how to advise.
Less about content, more kind of about your journey, how you got to where you are.
Yeah.
So as I look around the room, the majority of people here are students, which I'm super excited about. Thank you, everyone. So what has been one of the biggest challenges in the development of your career? How have you identified key moments or key opportunities for growth for you? How did you get there?
Yeah.
Can that be translated to advice as some of the folks advocate?
Absolutely. Yeah. I think I tell a lot of students, first of all, don't let anyone say that you can't do something. Don't say that, because you didn't, graduate from a top 10 law school or do a fancy clerkship or, fill in the blank, that you can't go on to do something that you really want to do. So don't let anyone ever tell you that, because it's not true. I think, the way that I was able to get the job that I have now is through the co-op program and improving myself within the co-op program. So work hard, prove yourself, make yourself helpful and useful, and that's how I was able to eventually get the job that I had, but not after a tremendous amount of rejection. If I had like $1 for every cover letter I sent to an organization that I wanted to work at, with no response, I would be a rich woman. And also, like, don't feel like there's like one set thing you have to do, and then if you can't do that right away, that your life is over, because there are detours. There are if we're lucky, our lives are long, which means there are lots of wonderful things to do, on your journey. And the expression of life as the journey, not the destination, is somewhat true. And so I knew I wanted to do reproductive rights I was lucky enough to go work for the Center for Reproductive Rights right out of law school, but only on the 6-month contract. They said, you know, you were great as a co-op student. We can't give you a fellowship, but why don't you come here and work for 6 months? And I took a chance. And then I got put into a fellowship slot, and I ended up being there for 3.5 years. But then the money ran out for me there, and I went to work at Legal Services at South Brooklyn doing foreclosure prevention work for low-income homeowners before anyone knew what predatory mortgage lending was or that it was going to be the downfall of the world economy. And it was great, and I loved it. I never thought that's what I would necessarily be doing, and I did it for 2.5 years, and it was a wonderful experience. But I knew that reproductive rights was where my heart was. So when the job at the ACLU opened up, I applied. They called everybody I worked with at the center, and I had gotten that 6-month contract at the center because I'd done a co-op, and that's how I had my job at the ACLU and I've been there for 15 years. So it doesn't have to be a straight path, and you know, there are lots of ways to get where you're going, and there are lots of things to do for social good. You know, I love to litigate. I love being in the courtroom. I love writing briefs, but there are limitations to litigation, and there are so many other things to do in terms of policy and advocacy, you know, do what, figure out like what you like to do, both in terms of the issue, but also how you like to spend your day. And I think that that's an important part of being a happy lawyer.
Are there any skills that you've acquired that you never would have thought would have been part of your portfolio or part of your career development, or skills that maybe you wish you had latched onto sooner, anything like that?
I don't think so. I mean, a lot of it is just on the job. You know, it's like really, like I've been very fortunate. The co-op program is great, and the legal education here is wonderful. A lot of it is just learning like, you know, how to be a lawyer and while you're doing it, and having good mentors while you're at your co-ops and at your jobs. And I think that's part of it. I was gonna make a joke about math because I find myself doing math way more than I want to be doing math sometimes. Like, you know, calculating fees, and when I worked at South Brooklyn, and I had a total crash course. I think it's, you learn it as you go. Yeah.
Do you have any recommendations?
Yeah, I mean, I think there's a tremendous amount that you can do in law school when you graduate. I said the ACLU of Massachusetts for one, and they work in a coalition here locally. So I think that there's probably an If, When, How chapter here, probably. Yeah, okay, good. So that's probably one way to plug in. There was no such thing when I was in law school, so I went to volunteer for Mass NARAL when I was a law student, and felt like I was volunteering that way. And then when you graduate, there's so much you can do. I talked about this network of attorneys, for example, in Texas, that goes with minors to get their judicial bypass. That's, you know, if you don't spend your career, you know, doing reproductive rights, there's so many other ways that you can volunteer to do things here and there to help with the issue. The ACLU now has a platform called People Power that you can sign up for different advocacy, not just on repro, but on other things. So there are lots of resources out there, and this is the critical moment. I mean, we are at this moment in history where people's engagement on this issue is so incredibly important. And so regardless of where you're living or what you're planning to do, there is something for folks to do.
I have a lot of questions, and I will only ask two.
Okay.
So I apologize. But I think, you know, a lot of people who are in this room were excited about the new service provided for students.
Yeah.
My impression is that's going to be challenged pretty quickly. How do you imagine that will go down, and what are some, you know, possible arguments that they have to prevent that? And then also, I came from Chicago where we were trying really hard to figure out ways to regulate CPCs in a way that wouldn't be immediately struck down. And do you have any thoughts about how that's going to evolve as well?
Yeah.
So positive steps we can take.
Sure. So there are two medication abortion issues, and one is an FDA-approved pilot study about mifepristone by mail. And so that's been approved by the FDA. There's a study going on. Several states and providers are involved. That is not what is questioned. The other issue is Rebecca Gompert's Women on Waves program and sending medication abortion through the mail, and the FDA has started investigating. So I don't necessarily know how that's going to play out, but one of the issues about medication abortion delivery outside the context of a medical provider's office is the restrictions that the FDA puts on the mifepristone. They treat it like a very dangerous drug, and they have a black box called the REMS, which I forget what the acronym